Welcome, Amy. This is Amy Bryant, is the director of the conservatorship office here in Davidson County. I'll let you give the more formal name. And we really appreciate that she has come forward tonight to share information with us. And like we said, if you could wait till the end for any questions you might have for Amy, and you're welcome to ask them in the chat. That would be terrific. So Amy, I am going to turn it over to you.
Thank you very much for having me. Can you hear me?
You're coming through loud and clear.
Great. I'm in a public space. I had a 5:30 board meeting, and so I'm in a lobby. But do I need to share the presentation? Do I need to share the presentation, or are you going to share the presentation?
Don, I believe you have it. Were you going to go ahead and share screen?
Amy,
either way is fine.
If you want to control Amy, that's more than fine. If not, I can pull it up.
In other words, Amy, if you share it, you can move it at whatever speed you're comfortable with, or Don can share it and you can ask him to forward it.
Okay, I'll pull it up. I have it.
Okay.
So I can pull it up. So while I'm pulling this up, I am Amy Bryant. I'm the director for the Office of Conservatorship Management. And so our office was established in 2014 as a second layer of oversight for conservatorships in Davidson County. And so today I'll be giving a Conservatorship 101 presentation. It will cover conservatorships and other tools that could be used for an individual that may need help making decisions for themselves. So I think I need to push share first.
It'll share screen and then, yeah.
And then start the presentation. All right.
Start share. Yeah, there we go.
Let's go back. Oh, let's go back one. All right. So I'll just go here. So I'll start with what a conservatorship is. That's the question I get asked most often. And it's an arrangement that's established by law. And so the Tennessee Code establishes what a conservator is. And so a conservator is an individual who's appointed by the courts to make decisions for someone else that doesn't have the ability to make decisions for themselves. And then a conservatorship is the arrangement. It's the relationship between the person and the person with a disability that has been established by the courts. And so that's established by statute. And so in Tennessee, there are approximately 8,368 known conservatorships. The honest truth is that we cannot determine how many conservatorships there are in Tennessee because it's not a database. And we don't have a statewide Office of Conservatorship Management that keeps track of how many conservatorships there are. And so I called all 94 counties starting back in 2019, and I do it annually to figure out how many conservatorships they have or how many conservatorships they think they have. And so if I had to guess, there'd probably be about 10,000 conservatorships in Tennessee. The one thing that we do here in Davidson County that's not done in other counties is we keep a track of how much money is being managed by people under conservatorship. And as of November of 2022, there's a little over $110 million being managed by conservators in Tennessee. And so I'll go over the conservatorship process. So the law, as I said, is a statute. So it's Tennessee Code Annotated 34. If anyone wants to look it up, it is on the internet and you can look that up. There isn't a lot of litigation regarding conservatorships on the appellate level. And so the one case that tells how a person should be appointed, who should be appointed, the process that the court should take to do it, it's called In Re Groves. And it is the case, it was established in 2003. And so it's almost 20 years old, but it is the prevailing case that courts use to determine how to award a conservatorship or grant a conservatorship to a person that may have a disability. So there's some important facts to know about conservatorships prior to me getting into the conservatorship process. Conservatorships serve adults who the courts have determined need assistance in life choices or healthcare or finances. And so an interested party can file a petition for conservatorship. An interested party is any person that knows the individual or has some sort of foundational knowledge about the existence of the disability and wants to help them. A report from a medical provider is required to obtain a conservatorship. And so there's a medical form that needs to be provided to an individual that that is used by the judges to determine if the person needs a conservatorship. A conservator is appointed by the court after verification of the facts of the case, and it's proven by clear and convincing evidence that that individual needs a conservatorship. And so a conservatorship can't just be granted to an individual just because someone wants that person to be under a conservatorship. The conservatorship continues until the person with a disability no longer requires a conservatorship as determined by the court. And so typically a conservatorship terminates if an individual regains the ability to make decisions for themselves. If the individual passes away, then a conservatorship is terminated. Or if the individual moves to another state and it's determined there that they no longer need a conservatorship. But typically it's because the person has recovered and they no longer need someone else making decisions for them. And the conservator is required to file an annual accounting unless that is waived. So if a person is appointed conservator for a person's finances, they're required to file accountings with the court by law. And then there's an annual status report that's provided by every person that's a conservator that they must file every year. Is it too loud in here?
So I'm just wondering if the background noise is coming from where you are, Amy, and just in case, I'm going to ask everyone else to mute except Amy.
It could be in here.
Okay.
But there's no one else in here, so hopefully it's not in here.
Okay.
And then conservatorships are managed by the probate court clerk's office. And so that's in Davidson County, and in every other county across the state, because I don't know if this is a statewide thing, it's managed by either the clerk and master or the clerk that handles probate matters. So the players in the conservatorship process are several. The person with a disability that's at the nucleus of this process is called a respondent. And so that's the person with the disability. The judge is the individual that determines if the individual needs a conservatorship. The attorney ad litem is appointed if the person with the disability disagrees. So at any point, if a person disagrees with the conservatorship, an attorney is appointed to make this, is to advocate for their interest. And then in all emergency conservatorships, there's an attorney appointed as well. And then a guardian ad litem is appointed in every case unless that is waived. And so the guardian ad litem serves as the eyes and ears of the court. And so they are the lawyer that goes out and investigates the information within the petition and any other information as required by statute to go back to the judge to say that this person either needs a conservatorship or doesn't need a conservatorship. Typically, an attorney will file that petition with the court. Oh, let's go back. And then there are family, friends, and loved ones that are involved in the process as well. And then the conservator is the person that is ultimately appointed to be the person that makes decisions for the respondent. And so that's the person that's appointed. It doesn't necessarily have to be the person that petitions the court. It could be any other person. And by statute, there is a hierarchy of people that can be appointed for a conservator for an individual. So it will start with spouse or children or other family members and friends. And then if there is no one else available, it will either be a public conservator or an independent person. So a conservatorship is established by a petition. So any interested party, and so that's any person that is aware that the person may need help, can file a petition with the court. And so then the court determines if there is a need for a conservator, and then enumerated powers are removed from the respondent. And so the one question that I get asked most often is, what's the difference between a power of attorney and a conservatorship? And so enumerated powers are those rights and those powers that a person has to make decisions for themselves. And so in a conservatorship, that's taken away from them. In a power of attorney, that's not taken away. And I'll talk about that a little bit more later. But with the power of attorney situation, you are giving someone authority to make decisions for you, but you also retain the right to make those decisions for yourself. In a conservatorship situation, the person no longer has the right to make those decisions for themselves. So those are the enumerated powers that are taken away. And so these are the different types of conservatorships. There's an emergency conservatorship. There's an ELHF, which is an expedited limited healthcare fiduciary. And then there's a full conservatorship. And I'll go through the three of those. So an emergency conservator is a person that's appointed because there is an imminent risk of harm right now. And so the petition is filed by an interested party. Sometimes that's Adult Protective Services, sometimes that's a hospital, and sometimes it's a family or a friend that files that petition. A lawyer is almost always required to do an emergency conservatorship just based on the statutory requirements that are required. It would be very difficult for a person to do this by themselves without a lawyer. And so in all emergencies, the court will appoint an attorney ad litem. And that person is the lawyer that will look out for the interests of the person with a disability. And that's because this process happens very fast. And so notice must be provided to the respondent and any other interested parties. And then a hearing occurs, and then the conservatorship is appointed for 60 days. So the reason that an attorney ad litem is appointed is because the hearing must occur within 5 days. And so since everything happens so fast, the legislature wanted to make sure that the person with the disability was being, or the alleged person with the disability was being looked out for. So there's a notice exception for the emergency conservatorship. So sometimes these conservatorships need to happen right now, today. And so notice can't be provided immediately. And so if the petition is sworn and the court finds that the respondent will be substantially harmed before a hearing can be held, an ex parte hearing will happen. And that's a hearing without the person with the disability and without anyone else involved. And the court will appoint the emergency conservator. And so then notice is required to the person with the disability, who is the respondent, by the attorney ad litem. And so that happens simultaneously. And then if appointed without any notice, the respondent must be given notice within 48 hours. So within 2 days of this appointment, the person with a disability must be informed. And then there must be a hearing held within 5 days to determine if the information provided to the judge was appropriate. And then the 60-day time limit still follows. So an emergency conservatorship is still only for 60 days. I presume the legislature thought that was enough time to get something done, but not enough time or too much time in order for a person to commit some sort of malfeasance if they were trying to get this conservatorship under some unscrupulous terms. And so it's only for 60 days. And so another type of conservatorship that we have here in Tennessee that's not everywhere else in the country is an expedited limited healthcare fiduciary, better known as ELF. And so the difference between this type of emergency conservatorship and the normal emergency conservatorship is that the person has to be hospitalized. I am almost certain this is something that the hospitals came up with to help themselves, but it also helps other people. And so the person must be hospitalized at the time that this petition is filed. And so the petition is filed by an interested party. Most times these petitions are filed by the hospitals themselves. And then an attorney ad litem is appointed immediately, just like the other emergency conservatorships. And then if the court finds that there is no other option for this person, there isn't a POA for healthcare, and there isn't a family member or friend that can make medical decisions for them, then someone is appointed. And then the court appoints the ELF. Typically, that could be a family or a friend. Typically, it's not a family or a friend. If there was a family or a friend, this petition wouldn't be filed. And so typically, it's a lawyer that's on an independent list, and they are appointed to help this person during this process. And then the appropriateness hearing is held within 5 days as well. And so the thing about the expedited limited healthcare fiduciary cases is that typically the hospitals need their bed, and this person cannot consent to leaving the hospital. They cannot consent to a safe place, or they cannot consent to a particular type of procedure. And so a person has to be appointed in order to make that decision for them. I imagine that in Tennessee, we have this because we are one of the healthcare capitals of the United States. And this helps the hospitals with making sure their beds are free when they need to be free, or decisions are being made when they need to be made. We are a regional hub for the region. And so many people that have some sort of healthcare emergency that happens in another area are airlifted here to Nashville. And so we have this statute here. So the appointment is not a determination of incapacity. So with an emergency conservatorship and a regular conservatorship, it's determined that that person has an incapacity. That's not the case with an expedited limited healthcare fiduciary. It's just that that person cannot make decisions for themselves right now. And so, like I said, the time limit is 60 days. And then it's specifically for, I'll wait for these people to go by. All right. So it's specifically for discharge, transfer, or admission, and then financial arrangements for discharge, transfer, or admission. And so it's a very limited scope of what that person has the authority to do, which is different from an emergency conservatorship where that person has the authority to do whatever the court has given them the authorities to do. The expedited limited healthcare fiduciary can be removed at any time. And so if anytime within that 60 days it doesn't need to happen, then they will cease to have those powers. And then the court can vary time limits and statutes for hearings to expedite this process. So if the court needed to have a hearing within 3 days or within 4 days, as opposed to the 5 days, they can do that if that's something that needs to happen so that this person can get the help that they need. And then all time limits are mandatory. So for all emergency conservatorships, the time limits are very mandatory. If it doesn't happen within that time frame, a new petition will need to be filed. So full conservatorships, and that's what you will typically hear about within the media or with individuals that may need some sort of help. A conservatorship can be over the person, it can be over the property, or it could be over both. And it continues until it's terminated. And I'll go to the next slide. I think this talks about it. So, nope, it doesn't. So I will go back. So a conservatorship over the person is for an individual to make decisions as it relates to the day-to-day and the welfare of that individual. And so the person is making decisions about their health care, their medications that they use, doctor's appointments, where they're living, and different things like that. If you're a conservator over someone's property, then you're making decisions about their estate. So you're making decisions about how their assets are managed. Should a house be sold? Should a house be rented? What should happen with those finances? You're paying bills. You're making decisions for them and contracting for them. And so that's the difference between the two of those. So when is the hearing held? So a hearing must be held within 60 days. So if a petition is filed today, you have 60 days for the court to hear it. And here in Davidson County, a petition can typically be heard within 30 days now. They've caught back up from the pandemic. In some counties, I've heard a petition can be heard within a week. And so it shouldn't be less than 7 days, because that gives gives the petitioner time to provide notice to the person that has the disability or the alleged disability, and to any other people that are involved. The hearing date may be extended on a motion showing good cause. Typically, this happens because there isn't medical proof to provide that the person needs a conservatorship. And so you'll have many instances in which a person may need a conservatorship, but they refuse to go to the doctor, or there may be more time that they need to get to the doctor, or there may be a reason that more evidence needs to be brought to the court so that that conservatorship can be proven. And so that's an example of when it can be continued. And then in life-threatening situations, the court may schedule a hearing in less than 7 days. Typically, that's an emergency, however. If there's an imminent risk of harm, an emergency conservatorship is filed. So how does the court determine if a conservator is needed? And this was that in Ray Groves case that I told you about earlier. First, the court has to determine if there's a disability or an incapacity. And so the court does that in a number of ways, but most importantly is done by a medical doctor. And so a nurse practitioner can't sign that form. No other medical provider can sign the form, but an actual MD. And so that's a form that states the person needs a fiduciary and in what capacity they need it. And so if it's determined that the person does not have a disability or an incapacity, no conservatorship is awarded. If it is determined that there is some sort of disability or incapacity, then the court must determine if it's a full incapacity or partial. And so if they're fully incapacitated, then the court has to determine, does this need to be an emergency conservatorship that lasts only for a short period of time and the person will regain their ability to make decisions for themselves, or does it need to be a permanent conservatorship? And so that means it's permanent until that person may regain the authority to, may regain the ability to make decisions for themselves, but it's just going to continue until they see that further. If the person is partially incapacitated, then the court needs to determine if it's temporary or progressive, or if it also needs to be permanent, but then the court is determining what sort of enumerated powers need to be removed from this individual. So they may have the ability to make day-to-day decisions for themselves, but they may not have the ability to make property decisions, asset decisions, or decisions regarding their finances. The way that I see this comes up most often is when a person is elderly and they have lots of businesses and their spouse passes away. And typically one spouse has more decision-making powers, or they were more involved in the businesses, and the individual that's left just doesn't have the wherewithal to make those types of decisions. That could be like a partial incapacity. And so a conservatorship may be established over the property so that someone can be appointed to continue to make decisions for those businesses or those financial management things. And then that individual still has the autonomy to make decisions for their day-to-day living. And so those are the enumerated powers that I was saying. And so there's a list of enumerated powers. There are 16 of them that can be taken away from an individual. And then you can see those in statute. If you wanted to look at those, I won't go over all of them. Some of the typical ones are the right to contract, the right to make medical decisions, the right to make end-of-life decisions, the right to, there is a right to vote and a right to restrict mail and visitation. However, those are rarely used unless you're in a circumstance where the individual has some sort of harm that may be caused to them by someone else, or they're susceptible to falling for scams through the mail, and then their mail could be restricted. I haven't seen any cases where the right to vote has been taken away from any person that's under a conservatorship, even though it is in statute and it is allowed. I haven't seen it though. The one thing to note is that there are letters of conservatorship that are issued. So the judge will sign an order that says that this person needs a conservatorship, and then the person that's appointed must file an oath that says they will abide by the fiduciary responsibilities that the court has aligned for them, and then they're given letters of conservatorship that authorizes their authority. And so that's how that works. There are certain places where you may, or a person may, use their orders as opposed to using letters. There are many organizations, banks, and other institutions that will take the order, but the letter is actually the document that shows you are a conservator and you have the authority to make decisions for an individual. And it's typically attached to the order, which has the types of decisions that you're allowed to make. So I just went over this, but I'll just read it. And so, to the extent not specifically removed, the respondent shall retain and exercise all of the powers of a person without a disability. And so whatever is not specifically detailed within the order, that individual still has the authority to make those decisions. And then anything, can y'all hear that? Do y'all hear the back?
We can a bit. Where are you, Amy?
Oh, okay. What'd you say?
I said, where are you?
I'm in the Capitol View building.
I think I know where that is. Okay. Yeah.
In the Gulch.
As long as you're safe.
Oh, Oh yeah, I'm safe here in the lobby. I'm in the lobby. I'm in like a secluded place, but people keep walking by.
Okay.
And so the court may consider removing some rights from the person with a disability and then not all of their rights. And so those are called the enumerated powers that are given to the conservator, and then the rights that are taken away from the person with the disability. So what are the duties of the conservator? So the conservator is charged with making decisions on behalf of the person with the disability. And that's really dependent on the powers that are given to them by the court. They make all decisions, whether personal or financial, depending on the powers given to them, but they must be in the best interest of the person with the disability. So that person must determine what is best for this individual, not what the conservator wants for the person, not necessarily what the respondent wants, what's best for them. It says my internet connection is unstable, but is it good?
You're coming through. Okay, no problem.
All right, great. You must use least restrictive alternatives. And so if the court should not provide a full conservatorship, removing all enumerated powers if the person can make some decisions for themselves. So that's what that means. Additionally, if there's some supported decision-making tools that can be used or other tools that the person can execute that can be used instead of a conservatorship, that should be considered as well. You must follow the court's orders. So if it's not in the order, then you don't have the authority to make that decision. And so if you're appointed to be conservator only over their person, you cannot make decisions about a person's finances. That's not something you have the authority to do, and you shouldn't do. You must file reports with the court on time. The status report is due annually every year. And then there's a tickler for that in Davidson County that sends you an email to let you know that that's due. If you're required to make financial statements, there are different time frames for those. And so the inventory is due within 60 days. The property management plan is due within 60 days. And then there may be a bond that you may have to get if you want to be a fiduciary with someone's finances. And then when necessary, the conservator should ask questions or should ask for court permission and not forgiveness. And so that typically comes up if the conservator tries to buy a car or take a vacation or something of that nature, of something that's very large that they are trying to get done. They should ask the court if they have permission to do that prior to making that financial purchase. There may be some things the court may need to ask the court regarding welfare, but there's nothing that I can think of in statute. So the only thing I can think of would be getting permission from the court to move the person with a disability out of Davidson County or out of the county where they live to some other place if you are not comfortable making that decision yourself. But within statute, you're required to ask the court for permission to make any purchases over $500. So what does this all mean? So this means that the person has been determined to have some sort of disability or some sort of incapacity. And then once the conservator is appointed, that person is no longer able to make whatever decisions the court has determined that they can no longer make for themselves. And then the conservator must be contacted to make decisions on behalf of the ward or the respondent. And so typically the conservator should provide their conservatorship letters to hospitals. They should open up a conservatorship account with the bank and provide them with those letters, any other financial institutions, any other service providers that the person with a disability has, so that they all know that this is the point of contact, this is the person that you reach out to if you have any questions. And then the conservator must be included in all decisions being made for the ward or the person with the disability. And so once notice has been provided to all of those people that this person is now the conservator, they should be consulted. And so that typically happens. If it's not happening, typically a conservator will reach out to me and let me know. The most recent time that that's happened has been with the sheriff's department. One of the conservators reached out to me to let me know that the person was incarcerated and awaiting trial, and they weren't getting the information they thought that they should be able to get from the sheriff's department. It turns out the sheriff's department didn't know that individual had a conservator. And so once we got that ironed out, then the sheriff's department was able to provide information to that person so that they could make decisions for the individual. One thing I want to make everyone aware of is that the Tennessee Bar Association, Legal Aid Society, and the Office of Conservatorship Management put together this program to help individuals that have children with a disability that are in public schools that have reached the age of 18 to obtain a conservatorship without having to pay for the legal fees. Typically, it's between $2,000 and $3,000 to hire a lawyer in order to establish a conservatorship. And so those calls are coming to my office, and then we don't help people establish conservatorships since we monitor them. And so I was chair of the Public Education Committee for the Bar Association. And so there is this program, and if a person qualifies, they call the office, they call our office, the Office of Conservatorship Management. I'll do the intake. And I send that on to the Legal Aid Society of whichever region they live in, whether that's West, Memphis, Middle, or East. And then the Legal Aid Society will pair them with the lawyer that will walk them through the process of establishing a conservatorship for their now adult child with no legal fees for them. So I want to make sure that everyone's aware of this. And then I always want to make sure to let people know there are other decision-making tools that can be used. A conservatorship is the last thing that a person needs to have unless it's something that they actually need to have. And so I encourage people to do durable powers of attorney. It's a document that you would draft that you can sign while you have capacity that will determine who will make decisions. Should you not have the ability to make decisions for yourself in the future, or should there be some sort of dispute with that? You can get a power of Department of anybody can download and print out and sign. You do need a notary for that, but you can get that off there. A healthcare surrogate is a person that you've given authority to make decisions for you regarding your healthcare. And so that's something that you would tell your medical provider or tell some other provider that this is the person that's making decisions for you. A living will is a document that you align everything that you want to happen while you're alive. It's not something that happens once you pass away. So it's the document that you would use that would say you want to be resuscitated, or you want life-saving nutrition given to you through tubes, or you want the doctors to do anything and everything in your power to save your life, or not. If you want a DNR, that's something that you would put on that living will. You can also find those online. I think the Department of Health has living will on there too, that you can put the information in there, how you would like to live or how you would like to die. And then you can contract for professional services. So this goes into the supported decision-making ideas that have been come about within the last 5 to 10 years. And so if an individual has the capacity to make some decisions whereby they don't necessarily need a conservator yet, they can contract with someone to make certain decisions for them. And so if you have the ability to do that, or you have the wherewithal to understand that type of contractual arrangement, that's something you can do. The only limitation with that is that there is no oversight for that. So that's a contract between you and that person, or you and that entity, to make decisions for you. And right now the law hasn't caught up to that. And so there is no entity to oversee if that person is making the correct decision for you or not. But that's another thing, a tool that can be used. The one thing I want to make everyone aware of is that there is free training for conservators. Right now, there is no mandatory training requirement for any conservator within Tennessee. So you can be appointed to be conservator of a person's person or their property without any training at all. And so I am pushing for statewide mandatory training for conservators. And so I want to let you know that there is some training. And so the best way to get to know what it is that you have to do is to read the code. The average individual will not do that. And so sometimes local counties provide training. Davidson County has free online training through the Office of Conservatorship Management. There's also online training from the Conservatorship Association of Tennessee. And so they have online videos on their website. And then we have comprehensive training on our website. There are frequently asked questions. There are sample financial documents that a person can use. There are videos that explains all of your fiduciary responsibilities. And so I am pushing very hard to figure out how to get this mandatory in Davidson County. I will say the training that we have in Davidson County is not Davidson County specific. It is intentionally made to be used by anybody within the state of Tennessee. And it is used across the state by different jurisdictions. So it's available and it's free. You can check that out on our website. That's the conservatorship school, essentially, that I was speaking of. The conservatorship school are 4 videos and 4 quizzes that an individual can do to show that they have training to be a conservator. And so at the conclusion of each one of those, you're given a certificate that says you've completed this particular training, you have a fundamental understanding of these fiduciary responsibilities, and then you could be a conservator. And so I know there are some lawyers that use this as like a CYA for them. And so they'll have their clients to do the school and show that they've done it so that they can show they have told their client what it is that they're supposed to do. And so they can't come back later and say their lawyer didn't inform them of what their responsibilities were, or they didn't know they were supposed to do this or that. So I know that's used for that. And anyone can access that through the online link. And so our office also provides resources for conservators and then resources for the public. And so here are some of the resources that we have within our office, and then I can also direct people to if they need it. There's local court information, and anyone can call me and I will try to provide them with any court information that I know from across the state. General fiduciary questions, legal assistance referrals. There's a list of lawyers that we use, or list of lawyers that have told me that they can be referred out. I don't advocate for any particular lawyer, but I do have a list of lawyers that I can send out. There is information about abuse reporting. I report to APS if there's something that we've discovered during our informationals or our welfare reviews. I will report abuse to APS. There's information about government support. Fortunately, I used to work for the Division of TennCare, so I know a little bit about TennCare Medicaid, nursing home care, and long-term care services. But we also have on our website information about Medicare and food stamps and any other benefit that a person may need to get from the government. Frequently, I'm asked about housing and transportation. Unfortunately, in Davidson County, there's just not much housing, but there are transportation resources. And then there's mental health information on our website, addiction information, and then aging information. The one thing I want to say about addiction is that a conservatorship can't cure addiction. And so if there's a person that has an addiction and the sole reason that an individual wants to get a conservatorship for that person is that they have an addiction, a conservatorship won't help. A conservatorship is not a form of slavery. And so if a person has an addiction and they are not ready to take the steps that it takes to become sober, a conservatorship won't help that. Because that individual only has the authority to make decisions for that person. They can't force them to do anything. And so that's one thing that I have to tell people frequently. If you're dealing with a person that solely has an addiction without any other underlying factors, a conservatorship may not be the best avenue for them. So I just want to point that out for you guys too. And that's the conclusion of this. Sorry for all the interruptions. I didn't have time to drive back to my office in order to do this presentation. So I'm here to answer any questions that you guys may have.
Well, Amy, first of all, thank you. I mean, and we knew that you didn't have the the time for this. So taking the time out to be here is very much appreciated. What I'd like to do is take down the screen so that we can see people, and then I can help you with if anybody's got hands up for questions. And so does anybody have any? I know I have questions and comments, but I want to know first of all if any of you have. Jennifer, we'll start with you, and then we'll go to Mark.
My question is, I would like to go back to voting.
Mm-hmm.
If you are under a conservatorship, can you vote Do you have a right to vote? Or is that taken away?
Yes, you do have the right to vote, but I will say in statute that can be taken away. I've just never seen it taken away.
Okay, thank you.
Mark?
Yes, again, thank you, Amy. This was really helpful. I do have a question. It seems quite clear that legal assistance would be necessary for a family that was seeking conservatorship. But I thought I heard you, and that is expensive. I thought I heard you mention that if there's, in the case of an indigent adult child, is there a possibility of getting free legal assistance or waiving fees of some kind? I thought I heard you mention that.
Yes, so through the Tennessee Bar Association, if you go on their website, there is a pro bono conservatorship initiative. And that is typically for individuals that have adult children that need a conservatorship, typically under the age of 30. It's rare that a person gets to the age of 30 that has a severe disability and their parents haven't been told they need a conservatorship. And so that's a function that's done with legal aid, but there are lawyers across the state that have agreed to do those conservatorships pro bono. I do know there are some lawyers that will help people get conservatorships if they don't have the finances to do so. However, if it's an emergency, that's unlikely to happen. And so you may have adult protective services that might file the petition for an emergency, but I don't know of any other free ways to get an emergency.
And if I could follow up, that of course would imply that the disabled person is him or herself okay with getting a conservatorship instituted. But if it's a case where they're somewhat hostile for that, but clearly still do need a fiduciary kind of arrangement, somebody to help them, then in that case, it's really up to the family probably to field any expenses for that. Because the individual with the disability would not, him or herself, be interested in doing that.
Yes, so for the pro bono one, everyone has to agree. But if a family thinks that a person needs a conservatorship, they can file. And there may be lawyers that are able to help, or adult protective services can help, because adult protective services will help in an instance where a person is at a severe need for a conservatorship, but they have limited resources as well.
Thank you. Oh,
you're welcome.
Amy, I'd like to make a couple of comments, and then we will go to Norma's question. And so I think I didn't know about the issue of, if somebody had a prior disability and then when they turn 18, they can do that. I want to make sure we're pretty clear here about what we're talking about, because a lot of the folks that we have are adults with full intellect. These are not individuals. A lot of the disabilities, and Amy, please correct me if I'm wrong, if I've got a different take on this than what you think. So I had a sister who had developmental delays, and Jody had, was born with them. And so she had an IQ of between 68 and 70. We never actually took full conservatorship because we never wanted to take her rights away. But, there are people who, from the time they're children, they may have limited intellect. They might be very vulnerable. They may not have the cognitive wherewithal to make decisions for themselves. A lot of the individuals that we have here at NAMI, when this question comes up, are individuals who have a mental illness, which can be something that, they may not have insight on it. And there may be an addiction that goes with it, a co-occurring addiction that's very common for us. These individuals may not be making, decisions, good decisions, or what we consider good decisions, but they have a right to make decisions for themselves. And we have to be very careful. The other thing that you'll see with a conservatorship is you're taking someone's rights away as an individual. This is a very, very serious thing. And it's not taken lightly. I'm so glad you're there in place, Amy. It bothers me honestly to hear that people don't even know what they're tracking in the other counties. That really concerns me. I can see that to be ripe for abuse of people. But I just want you guys to keep in mind, there are other tools that Amy mentioned, shared decision making. There's the power of attorney that somebody, develops. We see a need for conservatorship in extreme cases. Extreme cases for us that I've seen a couple incidences of people trying to chop their own limbs off. I've seen a couple cases of somebody trying to pop out their own eyes. And this is while they're sick. Most of our people don't rise to that level. So keep in mind that this doesn't, even if you get a conservatorship, if a professional that's working with this individual you can't make people do things. And I think that's something that you were saying, Amy. And if you could speak to that a little bit, I think that would be great.
The most common time that I see that a person with a mental illness and maybe coupled with addiction will need a conservatorship is when they need to get back on track, or they need to get on a steady regimen of whatever their medication is so that they can get to a place of stability. And so I have seen several conservatorships for people with mental illnesses, whether that be schizoaffective disorder or some sort of bipolar disorder, and they get on their meds, and it may take a year, and then they go ahead and live successful lives on their own, and those conservatorships are terminated. So sometimes it's just a temporary thing that's longer than the 60 days for an emergency conservatorship, and then those are the types of things that happen. I think that's what you
That's kind of what we're alluding to, but we do get people that think if I get a conservatorship, I can make this person do what I want them to do.
There are lots of people that think that, and I do have to tell people on a daily basis that I understand what you want to do. This isn't going to help you in that manner. It can help in this fashion. What do you want to do? And so there are a lot of people that think that if they get a conservatorship, they can control that person. And the honest truth is, unless that person is incarcerated, they can't do that. I did see a question in the chat regarding incarceration. It says, what type of conservatorship would you need if a loved one is incarcerated? So it's the same type of conservatorship. And so many times the conservatorships I see for individuals that are housed at Lois DeBerry are conservatorships for medical purposes only. And so it's typically when an individual has some sort of mental illness that they either disagree with or completely deny that they have. And then a person is appointed to make those medication decisions for them. There is one thing that happens at DeBerry that I don't agree with, and is that they can require the person to take medication by injection, even if they refuse to do so, which cannot happen outside of incarceration situation. But that does happen, and that's something the conservator can make a decision about in that place.
Thank you very much, Amy. We had a question from Norma, and it said, what happens in the event that a conservator dies or becomes disabled during the course of their conservatorship? What happens in the interim to the ward, to the respondent?
So a successor conservator is appointed. So that happens more often than not. Typically when the people get older, especially during COVID. And so in Davidson County, there's a list of independent conservators that could be appointed. In the state of Tennessee, there are several agencies that can be appointed. It really depends. So if the person is being cared for by some other care facility, they will usually reach out and tell someone that the conservator, they can't reach the conservator, or the conservator has passed away. And then
Amy, you muted all of a sudden. I don't know what happened.
Oh, I may have pushed it. I may have pushed it with my finger. And so I was saying that someone will alert the courts that a successor needs to be appointed typically. Now, I have seen a situation where a person passed away and they had disabled adult children in their home. And it took a while for the police and adult protective services to find out about it. But once that's found out about, then someone else is appointed to be their conservator. And so I don't know when I muted myself, but there's a list of independent conservators, and there are agencies that can serve as conservator for an individual that doesn't have family.
And we would really encourage you here at NAMI to contact us when you're dealing with, yeah, what we do is not magic. You guys know that if you've been with us. None of this is easy when you have a family member that has a mental health condition, especially if they lack insight. But we always want to give the opportunity to the individual for self-empowerment, because that's how they're going to grow. That is how they're going to learn to understand their own illness and develop into a state of managed recovery. We see Don and I and those of us, Vicky's over there in Dixon, you know, we see a lot. You know, we see a lot that goes on, and we see some really tough things. But we also know that it takes, none of this is a quick fix for what we deal with. It takes a long time for somebody to recognize first that they have a condition, because it's their brain that's acting out, not their pancreas or something else. And then we have classes for them as well as classes for families to help them understand, help communicate with people, and what resources there are out there. So would just urge you to be careful, you know, and do the least restrictive thing that you can. But occasionally we do know, and we see it, there are some very serious things that happen that especially may require an emergency. And I've heard of the ELF being used, and I've definitely seen it. I'm very well aware of what you're talking about. That's where we sometimes come in as an advocate agency. And so we have seen where hospitals may want to free a bed up, you know, for somebody else, but we've still got a person very deeply in suicidal ideation and still very much of a threat to themselves. And we will sometimes step in. We encourage families to do this. We train families to how to advocate for themselves and their loved ones. But if that's not being paid attention to, we will put the weight of our agency behind it. Go ahead, Mark.
Yes. Robin, in light of what you were just saying, which I certainly appreciate, you know, the self-empowerment for a mentally ill individual is the ideal. It's good. It's what we want. But when in a case where there's just this resistant, absolute stubborn lack of insight, they will not make a choice to seek medication or diagnoses, and it results in problems such as psychoses and delusional thinking to the point where they are, in fact, truly in danger. In a case like that, am I correct to hear that seeking a conservatorship in that case would not be necessarily regarded as an infringement upon their individuality and choices?
It would tend, sometimes, Mark, and you know, the court will have to look at it. If you got a lawyer, they would look at it. But the kind of cases that we're looking at would be, like I said, we've had cases where people have tried to cut off their arms, pop out their eyes, you know, think they're being poisoned and starving themselves. You know, the delusions that can come with some of these conditions can be incredibly serious. And the other thing that we find is they tend to strike out most at those that are closest to them.
Right.
And that is extremely common. And sometimes having a third party in there can be helpful. It's so frustrating for family members that are trying to get somebody, you know, to recognize what's going on, and they'll say, you know, honey, I see this, and I know that you think I'm trying to harm you, but I'm really not. Maybe if we did this, and they refuse everything you're trying to do, and a third party steps in and says everything you've been saying, and it's like, oh yes, and that is so hard. But you know, my answer to that, guys, is, does it matter who helps get it done? As long as it's getting done, that's what you want.
Thank you.
Mm-hmm.
We did have a question in the chat, and I wanted Amy to have a chance to elaborate on it. It was, is conservatorship recommended when the adult child is unable to control finances and unable to have stable work?
That really depends. With the inability to control finances, depends on if they have the capacity to make those decisions or if they're just unwilling to do it at this time. So it really just depends on the mental capacity for the ability to make those financial decisions. Sometimes people are just lazy and they don't want to. When it comes to work, it would also, I wouldn't say a conservatorship is needed if a person doesn't want to work or has an inability to work. A conservatorship is mainly for if a person can't make those types of decisions for themselves. But a conservator couldn't make a person work either. They could set them up in programs where they could go day programs or whatever like that. But I would say if they're unwilling or don't want to work, a conservatorship won't help for them.
Some of what we see a lot, what we'll see very often, especially after a major crisis, is the inability, a lack of motivation. People just get stuck, and sometimes it's the illness where they actually lack motivation because of the illness, or they're just they're ground down by it. And so we know that it can be really hard to get somebody just from the bedroom to the living room. We know that can be a huge step right there. And then getting them from the living room to there's some wonderful supported employment programs out there, but getting them from the bedroom or the living room to those programs is really hard. So we're actually, and it's going to be a while, but we're actually working with Vanderbilt. We're their first social work fellowship program for recovery. And so we actually have a third-year student from Belmont's occupational therapy program coming in to do a capstone with us to work on moving them from the bedroom to the living room, and then to a new program that we hope will start out of the work that we're doing at Vanderbilt, which is kind of a virtual clubhouse model of personal empowerment to get them, to move them on, to help them move on, and with personal empowerment, so that the motivation becomes theirs. But it is something that is just developing. Amy, I got your message.
And we have Vicky wanted to make a comment.
Sure, Vicky.
Yes, I wanted to mention that a lot of our people with mental health issues don't necessarily get those before the age of 18 or even before the age of 30. And many times that's something I just would want, the powers that be that are in contact with these attorneys. A lot of people can, even their mental illness can get worse, and then they need a conservator. So that was just a point I wanted to bring up. It's not necessarily an illness that appears before age 18, and it could happen at any time.
Right. Thank you, Vicky. I think that's really important. And then we do run into, and when you said it can happen at any time, we've seen, maybe we have a highly sensitive woman who she's managed, but she's always been highly sensitive. But then menopause comes and the hormones, we've seen people go into psychosis with menopause. We see people who have learned to manage their mental health conditions, but later they have an onset of dementia that throws everything off. And, so there's just a variety of things that can impact it. Amy is still here. She just had to go off camera. At least she was. There we go. So we just want you to make aware of that. If we can help you, if we can direct you, I think this is wonderful, and you will get the PowerPoint that she is sharing with us, which I think is terrific. And then there we go. Amy apparently had to might have had technical difficulties, but you will get that, PowerPoint, guys. And
I will say that once this meeting is over and I get the video to load onto my computer, I'm sending everyone who's registered and everyone here tonight the presentation. So you'll receive it sometime this evening, probably within the hour.
Thanks, Don.
No problem.
Yeah.
Thank you, Don. Hope you
And
feel
guys-
better.
Yeah. And we may not, always have the answers for you, but if you'll contact us, we'll try to get you to where you need to go. And Amy is one of those places. So guys, do you have any other questions, concerns, or comments? All right. We really appreciate your participation. And we know things can be very hard out there. We certainly understand that. And for you, Angela, and if you're the person, living directly with it, or if you're family members, this is not easy stuff. And I'm going to say again, people that have mental health conditions have very strong minds. They have to, in order to deal with this. And it amazes me what some people overcome just by living every day. I was very proud of my dad for that fact. So we want to thank you for joining us tonight.